So where do we tend to see gender discrimination in the big picture? Number one, advertising and sourcing, where we go to sources that are more likely to provide us applicants who are male. Advertising, there may be some subtle language in the advertising that also discriminates against women or men, for that matter, in those advertising um, outlets anyway. Sex-specific applications or interview questions where we might ask someone, do you have children? Do you plan to stay in the workplace if you get pregnant? Those sorts of things. And if you think that people don't still ask those questions, they do. Even if they think it's very, they don't really think about it as an issue. They're trying to be more casual in their conversation, but those sorts of questions are really not relevant in the workplace interview. Requiring one gender to work different hours or job positions. So we start to create female ghettos or male ghettos in organizations where women are limited in their mobility, or men may be limited in their mobility depending on the type of organization it is. Training opportunities, where often we will provide opportunities for males and do not provide the same opportunities for females. Discipline and termination differences, where we're more likely to fire somebody or discipline them if they misbehave versus allowing others to get away with it, whatever the issue is that they're being discriminated against. Seniority issues, right? Women get promoted less likely than do men, and so men will tend to have more seniority in the organization. Pays and benefits disparities. Again, we know that there are pay differentials between men and the pay that women and men get for the same work. That men tend to outpace women in terms of pay, even in what is considered to be a female-dominated area, like nursing. Male nurses will make more money than female nurses. Go figure. Differential conduct standards, express or unconscious. So we have certain expectations about behaviors, and usually those behaviors are focused on male bias about what is appropriate behavior versus what would be appropriate for women. And I can tell you this is not an uncommon issue. When I was working at a school before I came to SIUE, there were department chairs that told their female faculty that they were not considered serious academics because they took maternity leave when they had babies and would stop their tenure clock for a year so that they could have their baby and manage whatever they needed to do and then get back on track, to complete their tenure application. Women were not considered to be serious, as academics because of that. And not really considering legitimate differences between genders. For example, the firefighting apparel fit, and as you see in that case of City of Kansas City, Missouri, and Wedau, which is a disparate treatment case, where there are legitimate differences in the way that women's bodies and men's bodies work. And so, you have apparel that might work for men, but it might not necessarily work for women in the way it fits them properly or it enables them to be at their best performance given that. So these are considerations we should think about. Can a facially neutral policy differentially exclude one gender from or another from the workplace? And absolutely that can happen. It's disparate impact or adverse impact. If we have certain height and weight requirements to do a particular job, again, if the height and weight requirements are legitimately required to be able to do the job, that's not considered disparate impact. But if they are just arbitrary for the sake of argument, then they're really not very good. They are more likely to exhibit a disparate impact, and that then will differentiate or discriminate against women or men, for that matter, in terms of those height and weight requirements. Are there certain tests or screenings that will correlate with the ability to do the job? Again, if they're not job related, then we've just got these random tests out there or cut scores for those tests that are unreasonably high, and therefore women may not be able to achieve them. And when I'm talking about it, not intellectually, but I'm talking about like physical abilities. Like we know that men and women's bodies are built differently. I mean, obviously they have to be for the purpose of childbearing and things like that. But even beyond that, men tend to have more upper body strength, women tend to have more lower body strength. And so if we have requirements that expect certain upper body strength, if you simply have a standard that's abnormally high, you're going to discriminate against women who are not able to ever attain that level. And this was a big issue with firefighters, right? They finally recognized that we needed to set the standards at a reasonable level so that women and what could reasonably be done to be able to do a firefighting job. And so they did a detailed assessment of whether or not height and weight and lifting requirements were appropriate for the job. And by doing that, then they were able to set appropriate standards. And as long as people met those reasonable, validated standards, then that works out fine. But if they don't, that's not discrimination. That is simply people are not necessarily able to do certain jobs if they don't have the physical skills and the physical abilities to do that. And of course, the challenge also is, even if we set a particular standard, is there a better, less discriminatory method or requirement that we can use to still find the best person for the job? So when we see this differential impact, when we see disparate impact, it is important for us to figure out, is this legitimate? Should we be using it? Could we fine tune the measure a little bit and validate it more appropriately? Or should we just throw it away and try something else? Romantic favoritism is also an issue. You can see from Exhibit 8.9 in the case Womack versus Runyon, the courts ruled that um, while it might not be fair, to claim to have favoritism for your girlfriend, your husband, your whatever based on sex, right? Um, it's not illegal. And according to the quote here, Title VII does not prohibit preferential treatment based upon consensual romantic relationships. Consensual is the key there, right? An isolated instance of favoritism towards a paramour may be unfair, but it does not amount to discrimination against women or men in violation of Title VII, since both genders are disadvantaged for reasons other than their genders. So what they're getting at here is, so I might, because I'm an out lesbian, right? I might give favor to my female partner to do a particular job, or to promote them in some way, or to create an opportunity for them in my workplace. That's not unfair, because other women and other men are equally discriminated against because of that. They're not, or they're equally disadvantaged because of that. So it's not a form of discrimination based under Title VII. Now, you can have company policies that say we cannot have romantic favoritism and nepotism and things like that. That's a totally different thing. Under the law, however, that sort of favoritism is not necessarily illegal. Sex plus or gender plus discrimination is basically discrimination that addresses gender and some other factors, such as marital status or having children. Men are not subject to those same limitations, strangely enough, because they might be discriminated against because of their gender and because they may be married or have children. We just don't see that for men. And the key case here is Phillips versus Martin Marietta, where the employer believed that they didn't want to hire women with preschool age children because that for jobs that had variable schedules, because there was some sort of domestic duties assumption that went in there, like women were going to be required to be more involved with their preschool age children. Well, again, it's not the employer's right to make the determination that someone is not eligible for the job because they have children and because they may have childcare related issues. The presumption should be, can they do the job, and are they willing to make the adaptations needed to do the job? The company can say, this is what I need. And they can be to some extent flexible with that. I mean, it's up to them to decide how flexible they want to be, but if you have a legitimate reason to have a policy set up in a particular way, whether it comes to travel or work schedules, then it's not unreasonable to expect people to be able to adhere to those schedules. The issue is if you already presume that women wouldn't be able to do that job simply because they're women is not okay. And that's what's against the law. I mean, you can require any sort of work schedule, but you should not necessarily preclude anybody based on your own assumptions. And so you ask the question, say, these are the expectations. We can't negotiate on this because this is why we need to have it this way for customer needs or our workflow needs. And can you do this job? Yes. Then that's all that matters. They are responsible for handling their childcare responsibilities and things like that. You are responsible for making sure that you hire the best person for the job who can do the job. The courts have found discrimination in this situation, but mused whether the employer may have claimed a BFOQ exception, and that's in the next slide. We'll take a look at that in a second. So this slide is a great example of the ruling on Gender Plus and the impact that a really great jurist, Thurgood Marshall, had on the courts and how it interpreted the results. And if you don't believe that diversity matters, this is a great example of how he had a huge impact on the way things were interpreted, the way things were looked at, the way things were understood. And honestly, BFOQ cases really have not had any traction later on, given this idea of gender plus or sex plus discrimination. So this is really important step in history, in sort of the legal history, on how when we diversified our Supreme Court and we added our first, African American or minority justice to the bench, what a difference it made in the way that we interpreted things. So gender stereotyping is getting at how we assume persons of a particular gender must act in a certain way. And of course, gender stereotypes are illegal. They're prohibited under Title VII. And the watershed case is Price Waterhouse v. Hopkins. A female candidate was denied partnership because she was too aggressive, acted too male, and that she needed to be more feminine, act more feminine, dress more feminine, et cetera, et cetera. And in the end, this is what we call a mixed motive case, Price Waterhouse, because there were some legitimate reasons why they might have argued that she should not have gotten partnership. But once they added that she needed to be more feminine, act more feminine, et cetera, it messed up any legitimacy, if you will. It tainted the legitimate reasons. And so when we talk about a mixed motive, when there is a mixed motive, how do we know that the bias that's included in that, even if there are legitimate reasons, how do we know that there's not bias in determining those legitimate reasons? And that's one of the reasons why a mixed motive case is really important. And Price Waterhouse v. Hopkins was really fundamental in terms of helping us address this issue of gender stereotyping. And if you note at the bottom that the EEOC's approach to sex, when we think about that in terms of sexual orientation and transgender protections, it's about not conforming to gender stereotypes. A gender stereotype is a woman who loves a woman is transgressing the stereotype of what it means to be a woman, which is that you would be involved with a man. Someone who is transgender is transgressing the norms of what it would expect to be a biologically born female versus one whose gender identity was female. So the cases are really important for you to be aware of, and that argument was essential, for the EEOC and ultimately the court cases that made Title VII protect sexual orientation and transgender cases. I actually wrote a paper on this probably about 15 years ago, I think, that saying that this is going to be the approach that we should take in order to break down this notion of gender stereotyping, and in fact, that's the argument that they used. As we discuss gender stereotyping further, looking at Exhibit 8.13, where we talk about stereotypes, there are a whole bunch of different stereotypes that are typically seen in the workplace, which become ripe for discrimination charges. Number one, a woman being included in a workplace event is considered a buzzkill. Women employers would not consider some woman for the position because they questioned the applicant about future pregnancy plans and asked whether her husband would object to her running around the country with men. That women were not aggressive enough for certain jobs, that a lesser job position was sufficient for women and no woman would be named to a higher position. That men are the family breadwinner, that once a woman gets married, she's going to get pregnant. Once a woman goes on maternity leave, she won't return to work. Women cannot take the pressure necessary for certain jobs. If a woman is away from her desk, she's in the bathroom. Otherwise, if men are away from their desk, clearly they're talking about business to their colleagues. Women are unstable and not equipped for certain positions because of their hormones. Whatever. Pardon my sarcasm, but I read these things and I'm sure you're looking at this and going, well, these don't happen. This couldn't possibly happen. These all come from cases. These all come from legitimate cases over the years. So once you understand the arguments that women have been making for decades to have a legitimate place in the workplace, I think you'll come to appreciate the benefits and where we're at now, although there's still a long way to go. In terms of grooming codes, Title VII does not prohibit an employer from using gender as a basis for what we call reasonable grooming codes. And of course, what would be a grooming code for a woman would be different from a man, obviously, because the way men and women wear clothes, what they do, how they present, women are more likely to wear makeup, et cetera, et cetera. There are going to be some degree of differences, but it is important that we recognize, first of all, that they have to be similar or equivalent, but they don't have to be identical. So we can hold women to a certain standard, and as you can see in the Jesperson versus Harris case, that you can require women to wear makeup, on the job, but and not necessarily men in that circumstance. So the interesting thing in that particular case is that, and I disagree with this ruling, by the way, that the Ninth Circuit argued that there's no evidence in the record that that Jesperson's contention that cosmetics can cost hundreds of dollars per year and that applying them requires a significant investment of time. I will tell you point blank that the reason why I stopped wearing makeup a number of years ago was because of the expense and because of the differential expectation between men versus women. That women were expected to wear a full face of makeup and be this whole to-do, and men were not held to that same standard. I mean, they had to be cleanly groomed, but women can be cleanly groomed too with their haircut or, jewelry or nails or whatever. But, to expect women to spend hundreds and hundreds of dollars, and it was hundreds and hundreds of dollars in 1987 when I was working. And when I stopped wearing makeup, 1988 maybe is when I stopped, versus what it might be now, which would even be more. Again, and we don't want to wear cheap makeup because if you're wearing this stuff every day, that's problematic, and we want to make sure that we have stuff that's good for our skin and what have you. So it is important, though, to know that the employer can set whatever standards they want as long as they're reasonable. Haircut, hair length, nail colors, nail trimmed, differential colors in hair. I like to wear blue hair, but there are some corporate employers that might not like that. My employer doesn't care. I work for SIUE. It doesn't matter to them that I have blue hair because I like to have fun with my hair colors. But for some people, that might be an issue. We want to be careful that we're not having codes that affect opportunity because if we have differential impact on men versus women, if we differentiate and have different codes such that it looks like somebody is subordinate to another when they're actually the equivalent, that's a problem. For example, in the example in the textbook and here on the PowerPoint, a salesman wears a suit and a saleswoman wore a smock. The smock looked like the woman was subordinate to the man when they were equivalent. They were equal in their status in the organization. And so nobody would take women serious relative to men because men were in the business suit, which was very serious driven, and women were in a smock that made them look maternal. We want to make sure that our policies are not going to have are going to have an impact on and have different conditions of employment. those are not allowed. And a couple of examples that show up in your textbook talking about, for example, a woman lobby attendant was required to wear an outfit or a uniform that really subjected her to lewd comments and sexual propositions from males that would enter the lobby. That was not okay because wearing that dress code then made her a target, and that was not okay under Title VII. Or when a boss would say all the women have to wear skirts when the big boss is in town because he likes to look at legs. And again, that's a form of harassment, and it's a hostile working environment, if you will, but it's also a differential standard that makes women a target. So not only is this a form of sex discrimination, but it also could be a form of sexual harassment. So both of those, hand in hand, go hand in hand. So it is important to recognize that the employer can set the standards for what they expect in terms of grooming, and there can be some differences and some equivalents. They can be parallel as much as you can, but women can be required to wear makeup, and men are not. And even though I personally think that there is a disparate impact or there is a differential impact, not a disparate impact, I apologize, a differential impact between the impact on women and the impact on men, that women do have to take on the additional cost of all the makeup and the time put in. Because I don't know about you, but it takes a good 45 minutes to put on a beautiful, perfect face of makeup. It's a long time between foundation and powder and then blush and then mascara and eyeshadow and all the things that you need to do. It's a very detailed process if you're doing it right, and and it's expensive.